This is a very simplified overview of sentencing of the majority of environmental offences in the Magistrates and Crown Court. Sentencing guidance has been published by the Sentencing Council. Every court is required to follow these guidelines when sentencing environmental offences. There are 12 steps to sentencing. Usually, not all the steps are relevant to a particular case, but the courts and the advocates use this as a checklist when conducting the sentencing process. This is a simplified overview, so we're going to focus on the 5 highlighted steps. We'll return to these steps later on, but now let's look at steps 3 and 4. Determining the offence category, starting point and category range. The offence range is split between a number of category ranges. The offence range is obviously very wide as it has to accommodate different situations, but for a company, the offence range is between £100 for a micro business and £3 million for a large company. A large company has a turnover or equivalent of £50 million or more, a medium company a turnover of between 10 million and 50 million, and a small company a turnover of between 2 million and 10 million pounds. A micro business has a turnover or equivalent of not more than 2 million pounds. The offence category is determined by culpability and harm factors. Think of a sliding scale with deliberate as the most serious form of culpability and category 1 as the most serious level of harm. So, for example, deliberate would be an intentional or flagrant breach, whereas negligent would be a failure to take reasonable care to take steps to avoid the commission of the offence. A category 1 level of harm would involve pollution having a major adverse effect over a widespread area. A category 3 level of harm would involve a minor, localised impact. The table is an extract from the sentencing guidelines. It is for a micro business. At the bottom right, you will see the lowest sentencing range figure of £100. If this were a large company, the equivalent figure would be £7,000. This is the lowest end of the sentencing range if a fine is to be imposed. The range sets out a minimum and maximum range for a fine within a particular category. In the case of offending characterised as culpability, negligent and harm category 3, the range of fine would be between £500 and £5,500. The starting point is simply the point within the range at which to start calculating the provisional sentence. The court will then consider a further set of factors that may require adjustment of the sentence either up or down within the range. These factors are aggravating factors, such as a history of non-compliance, or mitigating factors, such as no relevant recent convictions. Step 6 involves ensuring the fine is proportionate to the offender's ability to pay, and this is a balancing exercise. An obvious example would be examining the financial circumstances of the company or organisation. It may well be that they have a small profit margin relative to turnover, so their ability to pay a fine becomes a relevant factor. The court could adjust the fine or give time to pay, or allow for payment in instalments. Step 9 involves the reduction of the fine for a prompt plea of guilt. So taking the example shown in the table where the business is a micro business and the offence category is culpability, negligent, harm category 3, the starting point is £2,500. If we assume there are no other adjustments to be made, then the fine would be reduced by, say, 30% as a discount or reduction for a plea of guilty. In this example, the fine would be £1,750.